Hello, everybody. Welcome to another podcast episode of the well-known by now series launched by the University of Nicosia School of Law, podcast series, audio and video podcast series to be exact, titled COVID-19 State of Exception. I'm really excited today because from the other part of the globe, all across the Atlantic, we have with us Professor Maria Pabón. Professor Maria Pabón is currently a professor at the Loyola University, New Orleans College of Law. She's a prolific author. She has posted articles in journals such as the Harvard Latino Law Review, the Georgetown Immigration Law Journal, the Hastings Women's Law Journal, and the Selton Hall Law Journal. She is also a frequent keynote speaker and presenter to members of the judiciary in judicial education programs, as well as to members of the bar and to those in legal education and higher education. In 2013, Hispanic Business named her one of the 50 most influential Hispanics in the US. She has been honored by the National Latino Law Students Association with an Excellence in Leadership Award and has been selected twice by the National Diversity Council as the most powerful and influential woman in Louisiana, where she is seated currently. Professor Pabón currently serves on the Diversity Committee of the Louisiana State Bar Association and on the board of the Louisiana Supreme Court Historical Society. Professor Pabón served as Dean of the Loyola University New Orleans College of Law between 2011 and 2015. During her tenure as Dean, the College of Law increased its bar passage rate and fundraising and enacted groundbreaking initiatives such as the Incubator Program and the Panama Summer Program. Professor Pabón, dear Maria, if I may, allow me to welcome you to our podcast series. We're really excited because we're going to discuss something that, a topic that we know a little about, the rights of inmates, of incarcerated persons detained within the federal penitentiary system in the United States. Welcome to our discussion circle.
Thank you so much. Muchas gracias and merci beaucoup. Coming from Louisiana, we have to have all our languages going on. That is a very generous introduction. Thank you.
Well, without further ado, let's go to our first question. Maria, can you please describe the basic tenets of the U.S. federal law regarding the legal status of prisoners? Are they persons living in a state of exception, as the title of our podcast series is, or are they considered right holders whose personal liberty has been just restricted as prescribed by law?
Well, I will start by telling you that they are definitely in a state of exception, in a situation where even before the COVID crisis, we had a lot of people incarcerated, and I thought I would share this screen with you so you can see what the numbers are. Can you see that? How many of these people in this exception are in the United States? And you have there the little picture of my, that's the university. It looks a little bit like a haunted house. So how many? In the United States, we have less than 5% of the population of the world, but 20% of those are incarcerated here in this country. So we are number one in the world. Of course, we don't know exactly how many China has. They don't report so well, but if we knew, we would be either second or we are first. Where these people are in this state of exceptions are in prisons where they're serving sentences, or in jails where they're waiting, or the federal government detains a lot in immigration detention. And these are people who have not been found deportable yet. They're just, the new Trump administration rules are that you have to be detained while you're pending your hearing. And it doesn't have to be based on any criminal conviction. It could even be humanitarian and such. And then, to me, the saddest, the young people in juvenile facilities nationwide, they're detained as well. So I wanted to know for you the distinction between what are the detainees, and there are big numbers of them, and inmates who are the ones serving their sentences. So with that as a background, they, here in the United States, they quantify, or I guess in prison research, you count how many prisoners by your 100,000. So our number here in the United States overall is 698. But for Louisiana, the state that I'm in, it's 1,052 per every 10,000. And those are the highest number in the world and the highest number in the United States. In comparison, where you are in Cyprus, there's only 85 people incarcerated out of 1,000. So it's a lot of people, a lot of folks who are in the United States and in Louisiana being detained. In fact, here we have a federal facility in Oakdale in Louisiana where we've had already deaths of inmates because of COVID. So we're dealing with some really difficult persons in exceptional circumstances. Now, if I may, Dimitrios, here's another screen that I wanted to share with you, in which it shows, sorry, I'm looking for it. Can you hear me?
Time.
Yeah,
Yes, yes, of course.
There you go. How many and where are they? There. How many people are locked up in the United States? So 698 per 100,000. So it's about 2.3 million people that are confined.
Shocking.
And yes, here's a pie chart. So we have the federal government doing its incarcerations, and that's this number down here. But then, right? But then we have the states, all 50 states, and that I'm sure includes my island of Puerto Rico. And then we have local jails. So that would be, for example, here in Louisiana, the New Orleans has a justice center, or there's a juvenile justice center, juvenile prison. And if you see, this pie chart gives you what people are incarcerated for the different offenses. And that's just jails, prisons, and prisons, jail. Then you still have the young people here. You have prisons, that will be territorial, like Puerto Rico, Virgin Islands, places like that. Look at this number in immigration detention.
Oh, goodness.
And then these folks in involuntary commitment, that tends to be civil involuntary commitment. And then look, they have Indians and militaries as well.
Oh, yeah.
So it's an enormous number of people, many for violent offenses, property offenses, drug, public order. In the local jails, like I told you, these are detainees. Most of them, right? The ones who are convicted are waiting to be sent to their places to serve their sentences. And then there's a small little chart. And in federal prison, there are immigration crimes. So you have these, and these are the marshals are the detainees, retrial, and then those convicted. Let me just give you an example so you know how this works. And I guess I can stop sharing now. When you have an offense in the federal system here, right? The federal government detains you and then incarcerates you. And then when it's time for you to serve your sentence, we're done sharing, right? Yeah. For example, in Puerto Rico, there's no federal prison. So then they have to take the prisoners and transport them to a central place in Oklahoma that is the receiving for all the federal prisoners once they're convicted. To then go, and they are not sent necessarily to prisons and penitentiaries near where their family can visit them. It's quite far. So I think hopefully that answers that question, right? Your first question for me.
They are actually considered people in state of exception because the personal life of the inmate, conjugal visits.
They're not allowed in the federal system, and very few states, if any, allow it. It's not like other countries.
Oh yeah, but this is shocking, and thank you for sharing. Thank you for pointing out. Let us move to our second question.
Yes.
Which is actually the legal status of federal prisons. Are they under the direct control of the state? Is there a synergy or an outsourcing scheme where the penitentiary powers are being given to private actors?
Sure. So let me tell you, it's a combination. So for example, either the federal government or the state government, they both run their systems of jails and prisons. For example, the federal government has the BOP, Bureau of Prison. That's where all the federal inmates are incarcerated. The BOP may contract, or a local one here, the Louisiana Department of Corrections may contract with private facilities to do this. Or for example, in California, in Texas, there's companies called like Wackenhut, Corrections Corporations of America, CCCA, and they are big companies that have shareholders who expect, revenue. And so when they get contracts from the government, their incentives are to maximize profit and minimize what inmates can receive. So you can imagine there's a tremendous tension, but there is a good number. The Bureau of Prison has its own operations as well, and each state has their own operations. It's a combination.
Okay, so we have three levels. Actually, we have three levels of penitentiary facilities, state facilities, federal facilities, and more or less facilities outsourced to private actors. We should point out that in continental Europe, especially in my mother country, Greece, the Council of State has actually declared that this power, the penitentiary power, is considered to be power belonging, pertaining to the
exclusive, right? Exclusive.
So it is exclusively destined for the state, for the administration. It cannot be outsourced. And this is really shocking. This is really something totally different for a lawyer coming from the continental system, coming from continental Europe. So it is important to understand that we have these three different levels, and I guess human rights, the basic rights of the inmates, are incumbent upon both the government, the administration, the federal government, the state administration, and private individuals. We have the so-called Drittwirkung. We actually use this German term in order to declare that human rights are opposable not only vis-a-vis the government, but also private actors having some kind of power or jurisdiction vis-a-vis the right holder. So can you please explain to us how the inmates' rights are being respected by the government? What are the governmental policies regarding the securing of the human rights of the inmates?
Sure. If you have a contract with the government, you're supposed to follow, right? Because the contract would say that similarly, you have to follow the rules and respect their rights and such. And I will tell you, I think it's very progressive of Greece to have done that. One state of the Union, California, has banned private prisons. So there's at least one state that said, like, look, should be only for the government. You don't want to put private actors who have the economic interests at heart rather than the best, what would be in the best penological objectives, So in terms of how they safeguard, here in the United States, the way this works is that we have a federal constitution, and then each state has their own constitutions, and those put like ceilings of rights, right? These are the rights that we hang. They're usually called constitutional rights or civil rights. Human rights is when we think about what comes from the treaties and such.
Okay, international law.
Exactly. So what you will see here in the United States under the Eighth Amendment, which prohibits cruel and unusual punishment, and that's interpreted by the United States Supreme Court. For example, there was a period of time that we had a ban on the death penalty based on a lawsuit and interpretation of that, a cruel and unusual punishment. About 8 years later, they overruled that, the Supreme Court, and so we still have the death penalty. States individually can choose to abolish it, like, for example, Illinois abolished it recently and such. So it's, again, this back and forth between the federal government and the federal backdrop of constitutional rights, and then each state, which could do more in terms of giving constitutional rights to the inmates. But let me tell you how this plays in real life. There was a big war on drugs. We have this mass incarceration, right? You saw those numbers. Yeah. So what is a priority is putting folks behind bars. What is not a priority is giving them any services or any ability to continue a meaningful life. Because not only do you have, even if you serve your time, the issue of what they call reentry, getting back into society, they've lost the right to vote. They call that felony disenfranchisement. They usually are not able to get jobs because of what's on their record.
Yeah,
and so, it's the collateral consequences are horrible. But inside the prisons, then, the requirement that they avoid cruel and unusual punishment requires, and that's what we talk about these cases from the Supreme Court, that you prevent serious harm, right? That if there's risk of injury to health, that the government actors not act with deliberate indifference to that, because otherwise you will be violating the Constitution. And the remedies are, one, an injunction ordering you to do this, and two, using that standard, but in a separate kind of lawsuit under some federal statutes, potential damages. But I'll tell you, Dimitrios, I was looking and they are not giving a lot of damages. There was a case where a man got tuberculosis. This is before COVID. He got there 2 months. They screened him because they've had tuberculosis, they've had MERS, staphylo, different diseases, and the man was infected in jail, and he kept asking, please give me. He had the incoming tuberculosis test where he was negative, and he kept saying, started coughing pretty immediately, and 2 months later, when he got the tuberculosis, sued for damages. Sorry, they were not deliberately indifferent, and they usually say, well, there's this, they call it a subjective component that you have to be, it's not more than just negligence, it's culpable. Do you know how hard it is to prove culpability? It's almost like a criminal law standard. So what you see is then a framework where, yeah, there are protections on the Constitution, but it's really hard for the prisoners. Most of the cases are done pro se, without a lawyer, or the ones who do, like when I've represented my client pro bono, it's because I've known my client for years, and so I was able to help them. But it's very difficult for inmates to get their rights vindicated in courts here in the United States.
So they don't even get their day to court. This is really interesting. It's really hard to, I cannot begin to fathom what these persons, how much pressure are they put under, what they have to persevere in order to finish their time, and then cannot be reintegrated, reaccepted into society. Allow me to ask you a simple question. I think it will be simple. I'm not sure because I know nothing about federal law of the United States. But anyway, what about negligence as a standard of culpability? What about committing a tort against the civil rights of this or that inmate based on the standard of negligence? Is this not acceptable, even in private litigation?
The Supreme Court has said that it's a higher standard of that. It's more like recklessness. It's above negligence and gross negligence. It's recklessness up to culpability. So they will not grant, I mean, the standard, the interpretation of cruel and unusual punishment is that, and that's the Supreme Court's standard, and that they are the ones charged with interpreting. So a case for negligence would not prosper. And in addition, we haven't mentioned that there's also the issue of the immunity of the state, right? Some of the cases that I've been reviewing talk about qualified immunity, and when you are able to pierce that immunity, when the state allows itself to be sued. And I'll tell you, at the end of the day, anything having to do with prisons, there's always going to be an argument of public safety, and that there's going to be a strong defense that, you know, it's hard to prove the culpability. And then if you're able to prove it, they will come up with a defense of, they did what they did for penological objectives. I was reading a case about a man who came in, pre-trial detainee, into a facility, and he started complaining of, he had a medication and they took him off the medication, and he was complaining of pain and seizures. You know how they responded? They said he was faking the seizures, put him in a padded cell, gave him no help, and he died. And then the wife sued, and no recovery. They were not culpable. It's unbelievable. That's why I'm so glad that you asked me to do this podcast, and I'm happy to do any others or entertain any of this, because the situation here in the United States is very difficult for people who, you know, they're judging you on one day that you made a mistake. Some of these people haven't even been adjudged guilty, and they die in jail. And coming to COVID, basically that's it. The inmates are saying, I'm serving a sentence, but not a death sentence, right? Those who have death sentences, there's a whole death penalty procedure, and that's not what they're there for. And the situations are quite dire in regular prisons and in immigration detentions, where we have inmates who have died already in those.
Can you please give us a picture, more or less, of what's the current state of play in both detained facilities under the COVID pandemic crisis?
Sure, I'll tell you what they have done immediately. They've stopped any visitation, because the idea is like, if they had been locked down on their own, well, it came, I guess, through the guards, or so no visitation, even for lawyers. The inmates themselves they're restricted in their movement, so they're all in their cells. So if you're in a cell with 6 people, if you're in a cell with just one, it's a little better. So it just depends what luck you have, what security level you have. I know they've instituted deeper cleaning. I know they've had, depending on your facility, some of them have received masks.
Face masks. Okay.
Right. Some of them are able to have hand sanitizers. Some no, because of the alcohol. There's prohibitions against alcohol because of this idea that inmates will make homemade alcohol to drink.
Yeah,
It's hard
by
to believe
using
they
the
would do it.
sanitizer, I
Yeah,
can't really understand
right.
how, but anyway.
Yeah. So and then at least for, I can tell you the conditions for the facility, federal facility in Mississippi where my client's at. They have not done any COVID testing, the one they do through the mouth or any through the blood, nothing. Every morning he says that some nursing assistants, not even registered or certified nurses, come around and take temperatures. And when people have a temperature, it's not clear that they remove them from there. They just stay there. And if they get sick, then they will take them out. And so it's a very difficult situation to maintain your health. In addition to the mental health, you've heard that there's been, even in the past, Dimitrios, a rash of suicides in these prisons because the conditions are so dire and they don't watch them very well. Imagine now under these circumstances, keeping their morale up. I will say the only positive thing that I know is that they have raised the number of minutes that you can make phone calls, and that they've instituted a regimen, and also the computer, the email, they've instituted a regimen, I think, where they wipe between each inmate. That is a positive thing, and I think they're very grateful for the ability to communicate more. They give them more minutes. The minutes for phone calls are limited, and the inmates have to pay for them. The families have to send them money.
Yes, I know.
So I hope that gives you a sense of how this is going on.
Yes, certainly. Maria, allow me to ask you a question, because I am studying public international law for a good 10 years now. I'm an international lawyer. And I know for sure that the United States does not accept any kind of monitoring or international judicial process in terms of human rights. Neither the Inter-American Court of Human Rights nor the relevant monitoring bodies, the relevant commissions of the United Nations, they have not ratified the relevant treaties in order to allow for private individuals showing them before the monitoring bodies of the United Nations human rights treaties via the communication procedure. So do you think that this zero international monitoring is making things worse? Because the Inter-American Court for Human Rights, I know for sure, it has a rich jurisprudence about prisoners' rights, and it actually has done quite a great job in Latin American countries and North American countries vis-a-vis standards and procedures in order to safeguard and positively guarantee human rights. So what's your insight?
Absolutely. It would be fabulous if the United States chose to join the international human rights community. It'd be fantastic. I don't know if you've heard this joke that says, how is the United States Senate like a graveyard? Because things go to die there, like the treaties. You send them to the Senate to be ratified and they never make it out. What we have here, in the absence of the international human rights community, I'll tell you who they are. It's the judges, mostly federal judges, who use their own conscience, which is, I think, maybe because at least in the past, to become a judge, you have to really have studied, and maybe they have picked up the human rights, even if it's not the regime adopted by our country. It would be at the very least something they know about. But federal judges back again in California ordered, like what I told you before about the ban on prisons, that was through law. But a federal judge in California in 2011, because of the prison overcrowding that was so massive, which is another thing that in the COVID area is horrible. How do you do social distancing when you're in an overcrowded prison? He ordered the release of inmates. A federal judge told the California Department of Corrections, you must release these people. They're too overcrowded. They gave him, Dimitri, I think it was 22 years. They kept giving them, because it was a lawsuit based on the 8th Amendment saying we're overcrowded, it's excessive punishment. Nothing. So a federal judge just ordered it. And isn't it similar to how we in the United States reached the equality of the races, at least in Brown versus Board of Education. That was through, again, a judge in Kansas to do that. So that's unfortunate.
That's kind of a judicial activism.
Judicial interpretation of the law to vindicate their rights, because certainly we're not having Congress, federal government is not doing it. And so it's up to individual conscience. And it's very hard to believe that the human rights and dignity of people are residing in the consciences of the judges, and that you have to pray to be lucky to get a judge who will do the right thing, because the law is subject to the interpretation that you could do the right thing. But they often choose
in
not.
the democratic tradition of the continental Europe, we would be forced to pose the question, quis custodiat ipsos custodes, who will guard the guardians, and what is there is a problem because we do not have a democratic process in order to name our judges. They're actually technocrats. They do what they do based on their specialty and how they perform in their professional field. But judges in the United States, they do have, let's say, they do have some kind of political role based on the process of naming them.
Absolutely, Dimitrios. In the federal government, they are selected. The president selects them.
Yes.
But in many states, including here where I am, Louisiana, Texas, they are elected. They run for office.
Okay,
and so you can imagine it doesn't get much more political than that. And so that's where, depending on where you land, the fight for the Supreme Court is always a very big one. You know, it's 5-4 split, and they're the ones who interpret the Constitution and all these rights. So it really comes down to the judges. And that's why when you read my biography and you talked about how I like to do judicial trainings, it's for that very reason. Because if you train judges, you at least open their minds, right?
Yes.
And the American Bar Association spends a lot of time giving feedback to when they're appointing judges. And right now, you said I serve on the Supreme Court Diversity Committee. I also serve on a court about language access, because one of the issues that for a lot of folks incarcerated is they don't speak English. So how do you even, I mean, that's how I started with my case with my inmate who's in pro bono in COVID prison. He had no idea what was happening when he was being sentenced.
Oh, goodness.
You know, so it's very difficult here in the United States.
I've been called time and again as a practicing lawyer to translate, because I speak 5 languages, including Spanish and French. So, so it's really astonishing that you have a person before a judge. He's actually sentencing him or her to something, and he's unable to understand the verdict.
What had happened in this case, in the courtroom, there will be an interpreter for when the judge communicates with the defendant. But between the defendant and his or her client or the attorney, they appoint sometimes lawyers who don't speak the language. In federal court in Puerto Rico. Unbelievable.
Honestly, yes. Maria, as this short discussion is coming to an end, I would like you to, let's say, draw a few conclusive remarks in order for our viewers to grasp the zest of this really topical discussion about the rights, the civil rights of the inmates and the threats they are under during the COVID pandemic crisis.
Absolutely. Well, thank you so much. Let me start by wrapping up and saying that right now, the most effective tool is for detainees, like those immigration detainees, using 8th Amendment and saying that you're being deliberately indifferent if you let me stay in a COVID facility, and here's the big if you're at additional risk. So inmates who have pre-existing health conditions, asthma, diabetes, heart disease, obesity, any number of things that make you at a higher risk. Those folks, from my experience and reviewing the cases, have been more successful in being released to serve their sentences or to stay in detention. Then they use ankle bracelets, monitoring. You have to have a landline, all that. That's for usual pretrial detainees. Your regular, average, healthy pretrial detainee is likely to stay in those facilities, even if they're horribly overcrowded. I've not seen any case be successful on just overcredit. One judge, I think there was a case in California where a gentleman was being held, he was 72 years old, detainee, to be extradited to Peru. And the judge said, he's too old. If you let him sit in this prison, you know why you detain people before trial? Because you think they're going to flee.
Yeah.
How are you going to flee when there's a pandemic, right? You're going to stay in your home. That's the whole plan.
Certainly.
Right. And then for inmates who are in federal prisons, who have the same risk factors, the age, the obesity, the health conditions, and have served 50% of their sentence, there's a compassionate release provision. And that's what I've used to file for my inmate. And we still haven't heard from the judge. So every day that goes by, there's more fear of infection. But every day that goes by, the judge is still thinking about ruling, and we haven't heard. So these are really difficult situations, and I want to thank you for giving me a chance to bring it to the attention of the world. And I'm happy to always engage in discussions with folks in Nicosia because about these issues, because we can all learn from each other very much. Certainly. So thank you so much, Dimitrios.
No. We want to thank you, Maria, for this informing discussion. We are really wiser, really puzzled, perplexed by the United States federal penitentiary system, but we certainly want to learn more, so we'll certainly to have a discussion again, either in this series or in our other series, the COVID-19 Newsroom podcast series. Thank you for being here.
Mucho gusto. Merci beaucoup. Absolument.
You're excellent, Maria. It's really nice meeting you. Thank you.
Thank you very much. Have a good day. Bye-bye.
You too.